Video 4 of 4, Exclusions, General Legal Advice on Exclusions.
This is a video series delivered by Arts Disability Law Center in collaboration with the Disability Law Intensive and the Disability Justice Network of Ontario. My name is Gabriel Resnick, and I am a staff lawyer at Arch.
And my name is Victoria Kassar, and I am a disability law intensive student at Arch and a law student at Osgoode Hall Law School.
Overview of video.
So what will the fourth video in this series discuss?
So this is the fourth and final video of the series on exclusions, and it will focus on Arch's general legal advice to assist in dealing with an exclusion when it occurs. Our advice will include the importance of getting written documentation, learning the procedures of the appeal process, and considering other legal actions if an appeal fails, for example, a judicial review or a human rights complaint.
Do you know when an exclusion has occurred?
So how does someone know when an exclusion has occurred?
So, due to the lack of legal guidance and inconsistent school board policies on exclusions, figuring out when a student has been excluded and what to do when they're excluded can be challenging. The most clear way of knowing that your student has been excluded is if you are given a letter outlining that the student has been excluded under Section 265 1M of the Education Act. However, this does not always happen. If a parent or guardian is told that the student cannot come back at school for a specific period of time, this could be argued as an exclusion.
How to document an exclusion.
Do you have any general advice on how to document an exclusion?
So, it's important to obtain written proof of the exclusion in writing. To do this, you can request a written letter from the school explaining why the student has been excluded and why they're therefore not allowed to be at school, and whether there are any conditions required for their return to school. If the reasons provided by the school are vague, provide a written document requesting for more detailed persons. So instead of just asking the school to provide more specific reasons, it's important to put that in writing that you're making the request for them to provide more specific reasons. In addition, make note of whether written documents includes instructions on the process of the appeal for the exclusion. So once they provide documents, ensure that the instructions on how to appeal that exclusion is present in those documents. Having these written documents is important to assist the student in ensuring that they can potentially overturn the exclusion. The school board could overturn the exclusion. But it's also really important following this when it comes to if the exclusion appeal fails in further legal actions. And in respect to these documents, it's important that you explain your side of the story for why the exclusion is appropriate. So once you receive the documentation, you should make a note yourself that you would disagree with the decision and explain exactly why you disagree with the decision. So for example, the student has a disability, explaining that this behavior is a direct response to their disability and should not have been met by an exclusion.
How to appeal an exclusion.
So once an exclusion has occurred and it's been documented, could the students and parents or guardians appeal the school's decision to exclude?
So yes, there is a built-in right to appeal an exclusion. However, it's important to get written documents from the school as to what the school board's appeal process is. And this is because the Education Act, despite ensuring the right to appeal, does not outline the specific process for appealing. And therefore, each school board has a different or may have a different process for appealing the exclusion. If the school does not provide you with written instructions on their exclusion appeal process, it's important that you request for this information. Unlike suspensions or expulsions, exclusions do not have this clear process. So expulsions and suspensions have a clear appeal process with an independent tribunal with a certain amount of days for when you need to do certain parts of the appeal. That does not exist in exclusions. For exclusions, they're appealed to the Board of Trustees of the relevant school board, and the decision to exclude can only be overturned by these trustees. Please note that school board policies may differ. I've already outlined that, but it's so important to remember that school board policies may differ, and therefore it's so important that the school and the school board provide the specific policies of what needs to be done in order to potentially overturn the exclusion. Finally, it is important to remember that the applicant wishing to appeal the exclusion, so the parent or guardian, their student wishing to appeal an exclusion, can access representation or have support during the appeal process. You can contact Archley Law Center if you wish to have representation throughout the exclusion appeal.
Legal avenues to appeal an exclusion.
So if the appeal did not overturn the decision to exclude a student, are there any other options available to address the exclusion?
So if the appeal is upheld by the board, there is some other steps that can be done once the decision to uphold the exclusion. And that is they can potentially file a human rights application arguing that the decision to exclude was discriminatory. Now, it's important to note that when filing a human rights application, you have 1 year from the date of the discriminatory event. An individual should also request to expedite their case, because without being expedited, an HRTO application can often take 4 years. However, to learn more about expediting a case, it's really important to contact Arch and receive that legal advice, because it is a very technical process. By filing a human rights discrimination claim, you can pursue remedies such as financial compensation for money lost or forced to be spent due to discrimination, or for injury to dignity, feelings, and self-harm. Non-monetary remedies could also be provided, which, for example, the main one in this case would be putting the student back into school. There's also remedies to promote future code compliance. So these are often referred to as systemic remedies or policy remedies. And these are, for example, ordering the school to implement a new policy that would require staff to receive human rights training in order to avoid such future incidents from happening. The next option outside of human rights application is filing a judicial review. In filing a judicial review, you must do so within 30 days from receiving the decision to uphold the exclusion. So once the school board trustees make the decision to uphold the exclusion, you have 30 days from that date of receiving that decision to file a judicial review. And what you're doing in this process is you're asking the court to find that the decision to uphold the exclusion was unreasonable. Applicants interested in pursuing either of these avenues should contact Arch, because it is very, very technical, and it is often helpful, if not required, to have legal assistance, especially when it comes to the judicial review process.
And do you have any final advice regarding exclusions in schools?
So the main initial advice is that it's really important to remember that each case is unique to the facts, and therefore the information that we have from uh, other past cases is really not directly relevant to understand exactly what may happen in your specific case if you do decide to do the legal option if the exclusion is upheld. In addition, it's really important to understand that when a student is excluded, they do still have the right to be in school. And that is a right that is protected by law, and therefore you should, consider receiving legal advice about the potential options that you have following the decision to exclude.
Contacting Arch Disability Law Center for legal advice.
And finally, if an individual wants to contact Arch, how can they do so?
They can contact Arch by calling us at 416-482-8255. We also have a toll-free number, which is 1-866-482-2724. We also have a TTY number, which is 416-482-1254, and a toll-free number at 1-866-482-2728. Or you can send an email to intake@arch.clcj.ca if you're unable to contact us by phone. Arch can provide summary legal advice about the situation upon your contact. Thank you.